I'll have to read from the script because otherwise I'll not make it in 20 minutes. So I'll ask you to tolerate me looking at my iPad. But first of all, I'm truly happy to be here with you. It's my first time in Leeds, but I very much hope that it won't be the last. And before I begin, I'd like to sincerely thank the Per Lindekrans Foundation and the Royal Society of Arts and Sciences in Gothenburg, because their generous support made it possible for me to join you live. Now, my talk is, as said, based on a section of my PhD thesis, which I defended this past September. In my doctoral dissertation, I had the space to lay out my points in full, a luxury I don't have quite today. So in preparing this talk, I've done my best to not skip any necessary steps in the argument. But for a fuller version of what I'll be discussing, I'll humbly refer you to the complete text, which is also publicly available online, and I'll be very happy to share it if it's hard to find the link. One last note before I dive in, I might occasionally use the term Anglo-Saxon, and more out of habit than of any specific intent, because I'm asking for your understanding, as I do not mean this term in my parlance to carry any modern ethnic, geopolitical, or let alone racial connotations. Now, my PhD focused on the Thegns in pre-Norman England in 871 to 1066 and in contemporary Scandinavia. The relevant core of my argument, in its most compact form, is that in England, Thegns were not a self-sustaining, primordial, timeless, and self-reflecting historical ontology. Rather, the word thegn, which I should note never lost its original meaning of servant, gradually came to denote an aristocrat, and it did so under the strong influence of what I call monarchocentric discourse, promoted by the Citizen Kings. This development took place, to borrow George Molyneux's book title, during, I quote, the formation of the English kingdom in the 10th century. I also argue that Archbishop Wulfstan's well-known and tidy framework for defining thingship is too simplistic. Despite the clarity of his presentation, the external signs of thingly status that he lists are better understood as its concomitants rather than causes or consequences. I've explored all this in greater detail in our previous panels in Kalamazoo and Durham, and more fully still in my PhD dissertation, which is somewhere with you. So I leave this part of the case here. What I haven't previously really covered in depth before an audience is thegns as landed proprietors. And here, perhaps unexpectedly, given the more iconoclastic nature of my earlier presentations, I find myself agreeing with the broadly accepted scholarly view, namely that thegns were landowners and vice versa. But in line with my PhD thesis, I'll qualify this statement. All late Anglo-Saxon landowners were thegns, but only from a certain royal point of view. So what did this view involve, and where did it come from? To answer that, we need to first take a slight detour and spend a moment on the problem of Bookland. Patrick Walmont once called it, I quote, one of the most fearsome devices on the Anglo-Saxonist workbench, end quote, and for good reason. The topic is vast, but as many of you will know, a few years ago, Dr. John Blair published a major article revisiting it. It's an excellent piece, brilliant in fact. But that being said, I must respectfully disagree with some of Dr. Blair's conclusions. Most importantly, with, I quote, the statement, I quote, that Bookland had largely lost its precise and restrictive meaning by at least the 960s and had no precise meaning at all by the 1060s. That may hold for Bookland as reconstructed by, among others, Walmont, that is, as a modern scholarly concept, yes. But I do agree with Dr. Blair in one crucial point, that the term Bookland was specifically southern, rooted in Wessex. And notably, the word thegn was too. Outside Wessex, Old English sources use different terms, like sake and soke, to describe the fiscal and legal rights of these landholders, often referred to as landrika. In Domesday, the equivalence would be a lodiary or free man who hold their own sake and soke. If we follow Frederick Maitland's method and study Domesday Book and beyond, and we pull all the evidence together, we can arrive at the following pair of conclusions. Now, Naturally, this list is not to be read from screen here and now, but this is more to show that I've done my homework. So the first conclusion is that during the period we're looking at, Bookland seems to have had a very clear meaning. It was one of the synonyms to refer to a type of landed property over which the king claimed exclusive rights. These rights included military service in the royal army, with the penalty of forfeiture to the king if the obligation wasn't met, or if certain other offenses were committed. The landowner also had specific rights, such as a share in a criminal's property apprehended on his land, and the, I quote, right of disposing of his land or giving it to whomsoever he pleases at deathbed. Outside of Wessex, I must emphasize, this type of landed tenure existed too, but under different names. My second conclusion here is that the king also claimed an exclusive superior lordship over every holder of such land. This meant he was entitled to punitive fines they incurred and the payment of a death duty, either in the form of military equipment or money in lieu. The West Saxon term for a landholder such as this seems to have been thegn, but in other regions outside Wessex, as I just mentioned, other descriptive terms were also used. Perhaps the clearest example of how these royal prerogatives worked in practice comes from the brief account in the Anglo-Saxon Chronicle about King Edward the Confessor's confrontation with Earl Godwin's clan in 1051. The Chronicle tells us that the king ordered the host to be assembled and ordered the earls to London. En route, the Chronicle reports, the earl's force, I quote, dwindled more and more as time passed, and with so much loss of manpower, Godwin's party gave in, and all of Earl Harold's things were, I quote again, transferred to the king's allegiance. With some context, we can understand what actually happened here. The Earl's troops were, in all likelihood, made up of the people who were personally commended to Godwin and his clan. But as landholders, they were also obliged to fulfill military service for their estates. King Canute's earlier laws state that deserting on a campaign was punishable by forfeiting one's bookland to the king. So it seems that Edward pulled this exact lever to wrest a large part of his opponent's forces from them. To secure his victory, the king then demanded that these landholders, thegns as the Chronicle overtly calls them, swear allegiance to him as their liege lord. This was meant to resolve the conflicting duties that these men faced between personal commendation to the earls and the general obligation before the king attached to their land. All of this took place in 1051. So here we see the system of royal prerogatives over both land and its holders in full bloom, especially if we consider the effective mustering of troops by King Harold just a few years later. However, there are subtle clues that West Saxon kings claim to be not only the supreme lords but also the landlords of their realm much earlier than this. Almost 40 years ago, Richard Abels argued that in the late 8th century, Mercian kings dealt with a weakening military by imposing the so-called three common burdens on all those holding land by diploma. The diplomatic records from the following century show that their West Saxon colleagues adopted similar measures. It is likely from this context that the Cerdasing's claims to obligatory military service from landholders originated. We don't know exactly how many of these landholders were personally commended to a reigning Cerdasing, and thus were thegns in the word's original meaning, people who in German terms enjoyed Königsnähe, that is, proximity to the king. The best we can speculate is based on the witness lists in royal diplomas, of which we just heard in Jeremy's presentation. In 2002, Professor Simon Keynes publicized his monumental Atlas of Attestations in Anglo-Saxon Charters. Based on it, my rough estimate is that at any one time, such personally commended landholders probably never exceeded about 200 in their number, even allowing for gaps in our documentary record. From it, by the way, we can also infer that those who received and held land with a royal diploma were even fewer. Yet, if we trust Doomsday's retrospective evidence, in 1066, England featured thousands of landholders across the country. Robin Fleming and David Roth estimated their numbers at about 4,500. Chris Lewis and Dr. David Baxter recently revisited these calculations, and they arrived at double this number. And the king, at least in theory, could claim his prerogative over every one of them, as the crisis of 1051 demonstrates. So the question is, how did this dramatic increase take place? I would argue that something quite new was afoot during the reign of King Alfred. In 886, the Anglo-Saxon Chronicle reports that, I quote, all the English people that were not under subjection to the Danes submitted to King Alfred. Or in Bishop Asser's Latin words, they, I quote again, turned willingly and submitted themselves to his lordship. Somewhat later, Alfred's Doom Book declared that, I quote again, every man shall abide carefully by his oath and his pledge. Patrick Wormald believed that this was the first example of a Carolingian-style general oath imposed on the whole populace. But that interpretation, I think, could benefit from a respectful update based on more recent scholarship. Judge Molyneux has argued that, rather than through a ramified bureaucratic apparatus, Alfred and his immediate successors governed primarily through their, I quote, greater subordinates, as Judge Molyneux calls them. And in an agricultural society, such as the Anglo-Saxon, these were bound to derive their economic power from landed property. Tom Lambert similarly observed that servicing kings confiscated landlords' estates, not the actual cultivators' plots. If we follow that logic, this oath and pledge must have been extracted first and foremost from these major landholders on behalf of everyone under their lordship. I'll give one brief example. In King Edward the Elder's Exeter Law Code, there's a clause that connects a landowner's failure to pursue cattle thieves on their estates with breaking of, I quote again, an oath and pledge which the whole nation has given, and it meted out, I quote again, such compensation as the Doom's Book declares. So, as the Romans would have said, sapiente sat. And so, in what may be a bold, but I think justifiable interpretation, it is possible that landlords' properties functioned as a kind of forfeitable pledge that came with this oath. This, in fact, may be how we should read the famous Fonthill letter. I'm sure many of you are familiar with it, but let me just briefly summarize the key details. Shortly before King Alfred's death, the ealdorman of Wiltshire, Ordulf, intervened with the king on behalf of his godson, Helmstan. Ordulf supported him in a legal dispute over 5 hides of land at Fonthill. All of this happens in Wiltshire. Helmstan also owned some unspecified Irfe at Tisbury, just south of Fonthill. Because Irfe often appears in context of bequests, it's usually taken to mean ancestral property. But there's also evidence that it could refer to land held by a royal diploma. Lest we forget, much of the bequeathed lands we know of had come with royal diplomas, and so it's hard to say if a diploma was a sine qua non of an Irve. Either way, Tisbury had, in fact, once been granted by a diploma, but we don't know just how Helmstan came to possess it. After the litigation ended in his favor, Ordulf returned Helmstan's original share at Fonthill as a temporary holding. Sometime later, Helmstan was also convicted of cattle rustling. At that point, a royal reeve, I quote, swept in. He assigned Tisbury to King Edward the Elder and Fonthill to Ordulf and outlawed Helmstan. When Ordulf asked him to explain, the reeve justified his actions by saying that Helmstan was a thief and, I quote, a king's man. Now, the shift in the text from the first to the third person in quoting the reeve may suggest that we're hearing something close to a legal verdict. Its inclusion also points to some hesitation on Ordulf's part. That he didn't know whether Helmstan was a king's man or not seems rather unlikely. After all, it was Ordulf who had brought Helmstan's case to Alfred and who twice spoke on his behalf, even when the king stayed at Wardour, which is close to Tisbury. The king also personally spoke to Helmstan's opponent, but not to Helmstan. So, given all that, my presentation should carry on for whatever reason. Yes, so given all that, sorry, I lost my train of thought. Yes, it seems quite unlikely that Helmstan was personally known to or commanded to the king. So perhaps Ordulf wasn't questioning Helmstan's status, but rather whether a king's man's Irfe could even be confiscated. Earlier and contemporary West Saxon diplomas don't say anything about that. But one 8th century merchant diplomat quite generously renounced all royal claims to the estate, even if the grantee's heirs commit a crime. Last but not least, it's also possible that Ordulf simply disagreed with the reeve about whether it was the king who should receive the confiscated Irve. Ordulf was Helmston's landlord at Fonthill, and as his godfather, he was tantamount to his lord from commendation in some respects. So perhaps Ordulf may well have felt entitled to Tisbury alongside Fonthill. My conjecture is that the 886 oath that Helmston must surely have taken, perhaps through an intermediary, automatically made him a King's Thane's man in the reeve's eye. And when Helmston violated, to use a modern analogy, the terms and conditions of this oath, in the reeve's opinion, Helmston forfeited his pledge, that is, his Irfe, whichever way he became its owner and however his godfather disagreed. If we follow the maximalist interpretation that I just presented, then another monarchocentric document from the same period can be read in a very different light. The year 886 also marks, conventionally, though controversially, the terminus post quem for the treaty between Guthrum and King Alfred. In its second clause, the treaty divides the people in two broad categories. First, those whose wergild was 8 half-marks of pure gold, and second, those whose lives were protected by only 200 shillings. On the Anglo-Saxon side, the treaty says, the latter were the churls on Gaffol land. Now, what exactly Gaffol land meant in this context is debated, but I tend to side with those who believe that a churl on Gaffol land in this instance was a landless person who paid tenancy rent rather than some sort of tributary render from his own land. The next clause in the treaty gives rules for dealing with accusations of homicide. This clause draws a social line between the King's Thanes and all those, I quote, of a lower order than that of a King's Thane. If both stipulations are talking about one and the same social spectrum, then the logic seems to be this. In the eyes of the treaty, or its drafters, perhaps better to say, King's Thanes included all churls who had landed property of their own. To summarize, King Alfred seems to have reconfigured his relationship with the elite by posing himself as the ultimate lord of all landholders whose lands he could encumber. Because of this, because of in its genesis personal nature of his lordship, to him they all appeared as his thanes, irrespective of the actual Königsnähe. These arrangements spread as the Södersings expanded their polity and annexed new territories. There is a very telling case of how this process might have worked in practice. The Anglo-Saxon Chronicle uses a very revealing language when it proudly reports a series of King Edward the Elder's victories in southern Danish Mercia. Not only did the locals submit and yield to King Edward the Elder, but they also chose and sought him as their lord and patron. These acts, the Chronicle reports, were sometimes confirmed with formal oaths. There's also a non-zero chance that as part of this process, landed proprietors in the Danelaw had their property rights confirmed and redefined according to the West Saxon template. The Libellus Ethelwalda Episcopi gives us a very good example. After King Edgar's death, a lawsuit took place in Huntingdonshire. The plaintiffs claimed a land estate through their great-grand-aunt, and they argued that she had petitioned King Edward at Cambridge at a time when Comus Tolley had forcefully taken control of Huntingdonshire. The court rejected the claim. The jurors ruled that the petition had come too late because Edward had already taken Huntingdonshire before moving into Cambridgeshire. And on the map you can see how this probably developed from west to east. So the implication here is thus: whenever a West Saxon king conquered a new territory, local landowners were offered to submit to the king and keep their lands under the West Saxon framework, or to lose both land and status. We don't have much evidence for actual, I quote, Booklandization in the modern sense, that is, issuing of new diplomas to the locals, but we do have some indication that Bookland-like encumbrance of land in the Danelaw met with at least partial success, because according to the same account, the jurors stated that apart from just two small estates, I quote, There was no land so free in the whole of Huntingdonshire that it couldn't be lost through forfeiture.
You've got 1 minute then.
Excellent, I'm reaching my conclusion. So what does this all leave us with? In late Anglo-Saxon England, thagnship and land ownership were indeed two sides of the same coin, but only because of the West Saxon expansion and its strong monarchocentric logic. Alfred could have been the first West Saxon king to present himself as the supreme lord of all landholders in his realm. From this monarchocentric point of view, it no longer mattered how close a landholder really was to the king. They all were now his notional thegns, because the word thegn had already connoted a personal bond between a king and a commanded follower. And from the same monarchocentric point of view, all land not held from anyone else was now notionally bookland. This was because the king had long claimed special obligations from holders of land by charter, and now imposed new prerogatives over it. As the kingdom grew, so did these rules across more and more of England, and so did the ideas that supported them. What we don't really know, however, is how deeply this discourse shaped the self-perception of those affected. As I argue in my PhD thesis, thagnship was probably not internalized as their primary social identity. We don't, for example, find anyone calling themselves thegns in the surviving wills, which are probably the closest we get to hear of their own voice. But as much as the king was concerned from a certain point of view, they all were his notional thegns. And in that sense, despite all the criticism, Archbishop Wulfstan was indeed quite right when he stated that, I quote, "The law of the thegn is that he be entitled to his book right." And with that, thank you very much. I hope I made it in 20 minutes.